So hello and welcome to CCCC Library's Copyright and Fair Use Q&A. I'm Allison Sills and I'm one of your campus librarians. I'm on the Lee campus, but you can always reach me by email. This email asills@cccc.edu. If you want to use found content in your classes, but you aren't exactly sure about whether you can or you cannot use something, this is a good place to start. So let's talk about four important concepts: copyright, fair use, public domain, and Creative Commons. Copyright varies by country, but in America, everything is copyrighted after creation, whether it's published or not, for the life of the author plus 70 years. That's the law right now. Ideas cannot be copyrighted, only created works. But after it's created, it's immediately copyrighted. We'll talk more about that in just a minute. And fair use is not law. It's very important to remember that. But it is a legally defensible position that you can use if you are sued. And it's supported by four factors. And we'll talk a little bit more about that in a minute as well. Public domain are works that have expired copyrights or things that are publicly available, like government documents. And Creative Commons is a location where authors go to provide their information with copyright. They usually forego the copyright or waive copyright or have certain minor restrictions to use for the common good and educational purposes. So let's talk a little bit about each of these concepts in depth. And if you have any questions, please put them in the chat. I'm going to talk about public domain first because it's very forthright. Public domain is all creative work that has no more exclusive intellectual rights that apply. Typically, this is for expired copyrights. So I'm just going to move right on to copyright. Copyright is the exclusive right to print, publish, perform, film, or record literary, artistic, or musical material and to authorize others to do the same. The framers of our Constitution believed that securing for a limited time exclusive rights to authors to their writings would promote the progress of science and useful art. This would allow creators to make money off of their work and to protect that work from theft. And the public would receive the benefit of the work that might not have been created if there were no financial gain available. So for instance, would Stephen King write and publish for free? Well, he might, but a lot of other people wouldn't. So in our country, in the earliest days, they wanted to secure that right. And it doesn't just cover published work, it covers unpublished work as well. Every personal letter, every garage band song that's new is considered copyrighted right after it's created. So let's look at the law. Copyright law has changed significantly over the years. In 1790, copyright only lasted for 14 years with the right of renewal for another 14 if the author survived the first term, but they had to ask for it. And so 28 years was the total of the original intent. And there are two types of copyright: copyright that is made by the individual and work for hire. Right now, an easy way to remember the law generally is it's the life of the author plus 70 years. And this is why Christopher Tolkien can still retain the rights of Lord of the Rings 50 years after his father's death, and why Amazon paid $250 million for the right to make the Rings of Power. But since 1790, both kinds of term limits have been elongated again and again, in no small part thanks to Walt Disney, who is listed as co-creator of Mickey Mouse, but actually paid as a work for hire situation for the creation of Mickey Mouse. And another reason why the protection was elongated is because between 1909 and 1962, not only did new formats come along like radio and television and filmmaking, they became a very lucrative business. So properties were running longer, like Gunsmoke was started in 55, lasted for 20 years. And in 1928, Disney created Mickey Mouse in an animated short called Steamboat Willie, which we probably have all seen or heard about in the news lately, because it just entered public domain. This animated character took off and created a media dynasty. Mickey still anchors the Disney brand, which is often characterized with the Mickey Mouse ears. It still has new cartoons being made about him and is raking in billions for Disney every year. The most recent figure I found was in 2003, which was 20 years ago. Mickey earned $4.7 billion for the company. And that was 20 years ago. Needless to say, Disney has been very anxious to retain the sole copyright on the mouse for as long as possible. And when Mickey was first created in 1928, copyright law said that Disney was entitled to him for 56 years and no more. But as 1984 approached, Disney was only getting bigger. Disney got anxious, so they quietly went to Washington and began lobbying Congress for a new copyright legislation, and they got it. The maximum term was extended to 75 years, and that lasted until 2003. But as that date came up in 1998, Disney lobbied again, and again they got the date for the work for hire copyright extended to 95 years, which is where we are now. And it's understandable that copyright law has matured because, again, copyright's intention is to incentivize creation of new work. It's an important source of income, not just for the copyright holder, but also for the US at large, because Disney's exclusive copyright brings billions to the US economy. And copyright was originally intended to provide income for 2 generations of descendants. And I'm sure no one in 1790 believed that the median lifespan, which was then only 45 years, that the human lifespan would increase by more than 32 years. It's now about 77 years that people live. So I'm actually shocked that Disney has not sought to increase the length of copyright again, but trademarks are forever, and Disney has trademarked every variation of Mickey Mouse. And since the image and the trademark name are virtually inseparable, and because Disney is notoriously litigious, I hope for their sakes that people who are seeking to capitalize on the mouse take very special care. And because I know there's already a horror movie called Mickey's Mousetrap that's coming out this year. So I guess we'll see what happens. And John Oliver should watch out too, because I watched the show last week and he has a Steamboat Willie piece in it. Steamboat Willie is also trademarked, but John Oliver's use could be considered fair use because it includes parody, and parody brings us to fair use. Fair use is a legal doctrine that promotes the freedom of expression by permitting unlicensed use of copyrighted material in certain circumstances. Please do not always assume that just because you want to use something for educational purposes that fair use always apply. It's not always. Often, yes, but not always for educational purposes. I will give you some examples. Just remember that there is no fair use law. There is the Teach Act of 2002 that has very specific guidelines that differ significantly between face-to-face classes and online classes. They differ because the online method of delivering material is often supplying a copyable work like a PDF or a link to a film. By contrast, if you're showing a movie in person, only the students in the room will see the movie, but if you're showing it online, people could transmit the link, could send the video to their friends. It could be transferred to a non-student. So there are some very specific laws, and I put these links here. I'm going to send everybody who attends a copy of this, so you'll have these links. But the more you read about fair use, the more convoluted it becomes. For instance, the invention of the VCR upended all common knowledge because at the time, making any copy was absolutely copyright infringement. In the Betamax case, the US Supreme Court balanced the desire of the public to use the immediately popular VCR against the copyright owner's rights by allowing the copying of television shows in something called time shifting, which is the ability to record now and watch later. The courts agreed this was fair use, but copying films or selling the copies that you made was absolutely copyright infringement. Right now, we are entering a very similar situation with the immediately popular use of AI-generated text and images, because companies like OpenAI and ChatGPT have not disclosed exactly how their AI models, how they're trained, what they're trained on. And authors are collectively suing the company as it's become obvious that their copyrighted works have been used in the training process. Their claim is that the works were used illegally or they were not paid for the use of the material that was used. This is another case of law having to catch up with technology, which moves pretty fast. I wonder what fair use argument they're going to use in court. I really don't have any idea. Until then, there are 4 factors that you can use to determine whether your use is fair use or not. And they are, the first one's purpose, and this is what will cover most of you. It's the use of material, transformative use. For instance, if you're writing a criticism about it, making commentary about something, using it for news reporting, teaching, which applies to probably everyone here, for research or for parody or satire. Parody is probably what John Oliver would use if Disney should sue. It's also the reason why South Park can do the outrageous things that they have done with the Mickey Mouse character in their COVID special. But you as instructors already have purpose covered with the teaching caveat. Nature evaluates the type of material being used. For example, nonfiction is more defendable to use than fiction because fiction involves an author's unique creativity. But if you're using parts of a nonfiction book about outer space, that is more eligible for fair use determination than using parts of a fictional movie set in space. Amount looks at the quality and significance of the part of the material you're using. For example, you cannot copy the heart of a work and distribute it. I would not copy all 5 of the best parts of a fictional work, especially if they reveal the best character or plot points, but perhaps maybe use 1 or 2. Penn State University's rule of thumb, generally adopted by universities, is 10%, or 1 chapter or 1 poem from a book of poems, or less. Effect considers how the use of the copyrighted material might affect the market for the creator. Could it be substituted for the original, impacting its market value? And Penn State page says that this factor is the one the courts most often rely on when reviewing legal challenges. 4 fair use myths, or 5. Myth number 1 is that any educational or non-commercial use is fair use. Again, apply the 4 factors. Educational is already 1, but please use more than 1. Myth number 2, using 10% or less is fair use. Again, if the heart of the copyrighted work is used without fulfilling any of the other 4 categories, it may still not be fair use. Myth number 3, any change is considered transformative. A transformative work must alter the original work by creating a new expression, a new meaning, a new message. And this is a good time to point out the fickle use of fair use. It has been ruled on differently in years past. Let's talk about Andy Warhol. Andy Warhol is known for making art out of other people's copyrighted works, such as the Campbell soup can you might know about. In that case, Campbell chose not to sue, but they could have. Andy Warhol has been sued at least 3 times, and all the lawsuits were settled out of court, presumably for large amounts of money, which he had because he was successful. But the legal battles didn't even end with his death, as per this picture of Prince. Last year, a lawsuit was brought against the Andy Warhol Foundation. It was brought and won. In 1994, Vanity Fair obtained a license to use this original photograph by Lynn Goldsmith. They gave it to Andy Warhol to create a unique piece with. Both artists were used, both were credited. And then Andy Warhol decided to make 15 additional portraits from the same photograph in different colors. Goldsmith argued this violated her one-time license when they tried to print this in another issue of Vanity Fair, and she won that lawsuit at the Supreme Court just last May. I wonder what would have happened if the previous lawsuits had gone to court, because I read an entire book on fair use, and the courts at different times have had different inclinations and ruled in very, very contradictory ways in different parts of the country, in different eras. It really is made on a case-by-case basis. Myth number 4 is including a citation makes it fair use. Citations and credit are academic standards, and copyright is federal law. So citing isn't enough, but please do it. Again, it's got to pass several of these factors, not just one, to be fair use. And fair use only applies to print materials. I think everybody has probably heard of Taylor Swift and Prince struggling to find ways to keep their copyrights of their music catalog. The founders intentionally wrote the law to be vague so that it could apply to new technologies, which it will as the AI generated material is put to the test. Just keep in mind that fair use is considered on a case-by-case basis, following all four factors. And there's also trademark and licensing laws. So it can and does get very complicated. Creative Commons. So where do you find works to use safely? There's lots of different places. Creative Commons is a great place to start. They're a nonprofit organization and a network devoted to educational access and expanding the range of creative works for others to use and to build on legally and to share that would otherwise be copyrighted work. And here's a link to that. I will definitely send that out. A good way to identify appropriate Creative Commons licenses is for you to look at the four main icons that they use. They use attribution, share alike, non-commercial, and no derivatives. If you see the by icon, that means the creator would like to be attributed. That's pretty standard, I think, when you use their work. If you see the share alike, that means the author is allowing you to use and alter the work, but they want you to, going forward, keep the work under the same conditions to share and allow modification of your work, to not claim it as your own. And some authors specifically state that they would like their work to remain non-commercial for perpetuity. And this means that the use may not be bought and sold for profit. And some authors will specifically say they don't want you to change anything. That's a non-derivative license. And any author may use any combination of these. The intent of most Creative Commons works is to allow educational and free sharing of ideas. So they're a great place to start. Here's some other places that you can go. I love Pixabay for images. Canva is an entire design platform. It's an amazing tool. It's like Photoshop, but easy to use. They also have artwork that they have both paid for and allow you to use, but also public domain art. If you want to try the new AI image generators, DALL-E 2 still has a free version. GenCraft has some very good artwork that it will do for you. I tried it out. There's some great things that you can use just with some simple word prompts. And there are a lot more links and resources on our library's research guide on copyright and fair use. There's a link to that. I can show you how to get there too. How do you decide if you can use something or not? I created this infographic. I wasn't going to talk about it. I was just going to let it roll out. Does anybody have any questions right now? Any copyright or fair use questions they want to share or ask? If not, I can go through this infographic really quickly. If you found something and you want to use it, first of all, is it public domain? If it is, use it. If it's not, is it Creative Commons? If they say it is, then use it and follow the terms of use. If it isn't, don't use it. If you found something and it's not public domain, can you obtain permission? If you can, use it after obtaining permission. If you can't, you can either don't use it or you can claim fair use. Fair use, are you going to use it in the classroom? Let's go with no. Is it non-commercial? If it is for commercial use, you can't use it. If it's not for commercial use, can you use just a small portion of it? If yes, then give credit. If not, then you can't claim fair use. Copyrighted material should ideally only be available to students in class. If you can avoid the distribution of future copies, try to do that. If not, follow the 10% or one chapter guideline. And just always remember that fair use is not law. It is a legal defense. So keep that in mind when you're picking things. So if you are going the fair use way, if you're using it for educational use, you've already passed the first factor, which is purpose. Are you going to claim it's transformative? Then also credit the creator, always credit the creator if possible. And remember that transformative means you're changing its meaning. Sampling had a problem for a while. It honestly is a case by case basis. Like Aerosmith and Run DMC, Aerosmith embraced the use of sampling, whereas there was another case with OMD who did not want their music used. And I believe they did sue and got money out of it. So just try to work in the original contract creator if possible, if by accreditation or contacting them if possible. And remember that criticism, commentary, news reporting, and satire or parody are almost always covered because we have to be able to critique the pop culture. And that's why Andy Warhol often wasn't sued, because he was a pop artist. So he used pop culture. So his entire artistic method was to use what was in the popular culture. But he was also very wealthy and very powerful and lots of powerful friends. So he also knew the content creators that he was using. And again, try to keep the amount as small as possible to make the point you want to use in class. That's all I had to say. Okay, question. I have a business class where I want to use slides from other courses involving multiple publishers. Do I need to give credit on each slide to the different publisher authors, or can I list all the sources on a title slide? That's an interesting question. I would, as long as you're giving, is this the PowerPoint? Where I want to use slides from other courses. I would credit them like I would a paper and put like a small 1. I don't know if you can see how I've done this 3 here. I've put them on the page that it went with, but if you have many, you could just put a numeral here, like I did at the bottom, and then put all of your credits on a final page. That's what I have done in the past when presenting at conventions.
Thank you, it helps.
You're welcome. Does anybody else have any questions? I keep a list of several sites where you can find Creative Commons. That's very good. And we do, let me show you how to, let me escape out of this and show you our library's website. We're already there, but it's right here, library research guides. If you click on research guides and you'll get this drop-down menu. If you scroll down to faculty and staff, we have lots of great LibGuides here for you. We have one on copyright and fair use right here that will give you a lot of links, a lot of the information that I just talked about, videos, breakdowns, and definitely links more about Creative Commons, more about the Teach Act, and what if it's not fair use and ways to get proper use. And you can always bring material to us and we can help you get the permission from the copyright holder if you need help doing that. Do pictures that come in instructor resources that the faculty member then puts in a PowerPoint need to be cited? I often do. I do. It can be a very small blurb underneath. It doesn't have to be 20-point type. It can be 9-point type, just to put it in there. And it doesn't have to be formally structured if you don't want to go that far. But you could definitely attribute the author if you know who they are or where you got it. Include a link.